everyone. My name is Terry Cummings, and I'm going to be presenting a topic called customer operations, liabilities, and insurance. The genesis of really putting together something like this was the fact that even in our departments, our bond department, carnet department, property casualty, and cargo department, we often work with the same customers, but we only have the relationship and experience with the customer as it relates to our particular product, the things that we do. So you don't necessarily know how that customer might interact with other departments and what other coverages they might have through Roanoke or may need through Roanoke. So this is a way to get some orientation and some basic knowledge about what kinds of business our customers operate in and what kind of products that we have that would meet those operational exposures. All right. So what are the types of services or operations do our customers perform in? So here's some, and these are a lot of our customers will do every single one of them. Some will do multiples of them. Some might do only one of them. There is no format that you can say applies to every customers. So we've got an NVOCC. That is just a term that means non-vessel operating common carrier. It's basically an ocean carrier without the vessel. You're acting as an ocean carrier, but you really don't have an ocean vessel. You're just representing yourself to the customer or to the shipper as if you were the carrier. An NVOCC issues house ocean bills of lading. So instead of their ocean bill of lading that might say APL, American President Line, it says ABC NVOCC Company. So you can see that to the shipper, they're representing themselves as the carrier, even though they don't operate their own equipment. An ocean freight forwarder is someone who doesn't issue their house paperwork. All they're doing is arranging transportation on ocean shipments. An international air freight forwarder, they arrange the air freight, and they also can operate as an indirect air carrier or a forwarder where they issue their house bills of ladings. Again, it might be Delta Airlines that issues the master bill of lading, but that freight forwarder, that international freight forwarder, could issue their ABC air freight forwarding bill of lading. So they're representing themselves again to the shipper as if they were the carrier. Domestic freight forwarding is really limited to the U.S. It is someone that will act as on behalf of the carrier. They're issuing house bills of lading. So they're issuing bills of lading as if they were the trucker, but they aren't the trucker. They're arranging domestic freight moves. The property or truck broker, so we see multiple terms to describe this next category. The technically right term is property broker. It's the type of authority that is issued for a broker. But we also see a lot of people refer to it as a truck broker. They're one of the same thing. They are someone who contracts with the carrier to move domestic freight, but they don't act like a carrier, so they're not issuing any paperwork that says they are acting as a carrier, okay? Customs broker. A customs broker is one that arranges transportation of the import transportation. So they're arranging the imports into the United States. They're doing the customs paperwork to allow that shipment to enter the commerce of the United States. So everything that has to do with the customs entry, all the paperwork, all the governmental authority regulations that have to be complied with, all the paperwork for that, the collections of duties, the payments of duties, all of that is what the customs broker does. Warehouse operators, Warehouse operators can operate different. We can have a warehouse that focuses on long-term storage. You can have a warehouse that only has cross-dock freight, meaning that freight is still moving in transit. It's not stopped. It's not being stored. It's moving through the warehouse. You can have warehousing that focuses on distribution or pick and pack kind of, or assembly or processing. So there's different warehouse situations. You can have warehouses that are bonded warehouses, which mean that they are operating in bond under the customs bonded permit, and they really aren't in the commerce of the United States. You can have foreign trade zones that are also kind of in a situation in bond. They're also not in the commerce of the United States. So there's a lot of different warehouse scenarios that you can operate under. And then lastly, you've got the motor carrier, and that is a domestic trucker that has their own equipment, right? Not like a domestic forwarder who acts like a domestic carrier but doesn't have trucks. The motor carrier actually has trucks. All right, so first off, those categories, those types of operations, well, which one require bonds? Okay, so you see not every one of them require bonds, but here are the ones that primarily require bonds. The NVOCC needs to have a $75,000 OTI or bond as an NVOCC. The ocean freight forwarder, $50,000 bond. The surface freight forwarder, which is the other terminology as domestic freight forwarder, they need a $75,000 bond. A property or truck broker also needs a $75,000 bond. A customs broker typically needs a $50,000 bond. There are other bonds that are needed for other operations, like, for instance, bonded carriers, bonded warehouses, freight forwarding that required, they're doing AMS filing. So there's other bonds that are needed, but these are the basic ones. Now, if you see the term like in parentheses at the end of each line, it describes who the obligee or the body that's requiring the bond. So you see the NVOCC, the bond is required by the Federal Maritime Commission. Same thing, ocean freight forwarders, the Federal Maritime Commission. So the surface freight forwarders and property brokers, those bonds are to the benefit of the Federal Motor Carrier Safety Administration. And then lastly, CBP is Customs and Border Protection. The asterisk that links the forwarder and the broker together basically is saying that if you have the same company with the same name and the same tax ID number, even if they have two operating authorities, one a freight forwarder, one a broker, they can share one bond for $75,000. They don't have to have two bonds. All right, so let's move into another service that we provide, and we could provide this to forwarders, to customs brokers, and directly to exporters, right? So it's an ATA carnet. An ATA carnet is basically a customs document. ATA is a combination of French and English words meaning temporary admission. Carnet is a French word that means passport or passbook. The carnet system is a treaty between governments, so everyone that has signed the carnet treaty becomes a member and are able to accept carnets into their country and issue carnets for goods going out of the country. So it's a passbook or passport for your goods that lasts 12 months, and you can take goods in and out of countries, back into the United States and in and out of foreign countries, as long as they're within the carnet system, unlimited numbers of times in the 12-month period without having to post duties and taxes for the cargo. If you did not use a carnet and you were shipping the cargo traditionally, then every country you would go in, you would have to either put up a deposit duty or a bond if they have such an instrument in that country to protect the foreign government that you're going to export the goods out of their country within the time period that you're allowed. So this gives someone a blanket passport that they can use unlimited numbers of times in the 12 months without having to post duty, without having to post bonds. It's the customs document. Okay. Now, going back to originally the types of services our customers are performing, which of those services, or which are the hats that they wear, have what we call statutory liability? So statutory liability or statutory cargo liability, I'm really referring to things that are regulated, things that are by statute you are responsible for. Because there is plenty of liability that's not a statute, but it becomes a commercial exposure and a commercial liability, or even, a legal liability, but not necessarily by statute. So what we're focused on now is what is statutory. So NVOCCs, remember the non-vessel operating common carriers. There's a lot of acronyms when we deal with transportation and customs. So you just get used to all the acronyms and the abbreviations. So the NVOCC has a statutory liability under COGSA. There's actually some other ones, but for the most part, we'll just focus on the majority of the time. The majority of the time, it's under COGSA. COGSA stands for Carriage of Goods by Sea Act. And the bottom line for COGSA is $500 per unit of freight. We're going to show a slide in a moment that will give you those monetary amounts. International air freight forwarder, those freight forwarders internationally that issue the house bills of lading, they have statutory cargo liability under either Montreal Protocol or the Warsaw Convention, depending again what countries are involved. Domestic freight forwarders are under the Carmack Amendment. That's the statute for cargo liability for a freight forwarder. Also true for motor carriers. Interstate motor carriers are also obligated under Carmack. However, the intrastate, so anything within the state, is subject to the state regulations, or really what they're to be found legally liable for. So there's not a statute per se for the state or with the intrastate. So here are the monetary liability amounts. As you see, ocean carriers, $500 per unit of freight. International air carriers, or the freight forwarders that we're talking about, is 19 SDRs if you were going under Montreal Protocol. The SDR stands for Standard Drawing Rights, and it's a form of currency that's used under Montreal Protocol. There's also Warsaw, which is the $9.07 a pound, or about $20 a kilo if you're under those conventions. Then we get into domestic. Domestic airlines, trucks, and railroads, and the forwarders. They actually don't have a specific dollar amount, limited dollar amount, like the international ocean carriers and the air carriers and forwarders do. It's actually more like a common amount, and I'll talk about that. So who else has cargo liability? A warehouse operator will have cargo liability. But again, there's no statute, whether federal or state or international statute, that governs cargo liability for a warehouse operator. But by default, without any reference to liability, limiting their liability, they become fully liable for the cargo. So typically, warehouse operators will issue some type of paperwork that limits their liability, both from a perspective of what the scope of responsibility, when they are responsible for something or when they're not. Could they be held liable for an act of God? Could they not be? So it talks about the scope, The other part talks about monetary. Remember, with cargo liability, there's two parts of every cargo liability discussion. One part is where am I responsible? For what acts, for what things can I be held responsible for? And the second part is how much, if I'm responsible, what's the monetary amount I'm responsible for? So it is when am I responsible and how much am I responsible? Those are the two sides of cargo liability. And by issuing terms and conditions and limited liability statements, it helps manage the liability of all of these operators and NVOs and things like that. So we often, when we talk about the scope of responsibility or when am I responsible versus when I'm not responsible, the term force majeure and standard of care comes. We also use the word reasonable care. So the idea is it's hard to make someone responsible when they didn't do anything to create this. It was literally out of their control. It was an event beyond their ability to stop it, like a force majeure. Or it is something that where they used a reasonable standard of care, that they did everything that they would normally do as a reasonable person would do. So therefore, how can you make me responsible for something that I couldn't have prevented? That's the idea behind legal liability. Could I have prevented it? Could I have done something? Or did I create this? That's part of the discussion of who's responsible and who's not. Now, when we see contracts like shippers contracts that contract with a carrier or with a forwarder or with a customs broker with an NVOCC, we will see contracts that will actually try to broaden this, what is known to be legal liability, broaden the scope of what you're responsible for. We see this all the time because shippers want to transfer their liability to someone else. And when someone who has a contract and is responsible and they subcontract that with someone else, they're also trying to transfer the risk to someone else because ultimately nobody wants to be responsible for things they didn't do. So talking about, again, the operations, the services that our customers engage in, we're also talking about the agencies that they have to get operating authority for. And so one of the agencies that are really important to know about is one that governs the interstate transportation. So there's multiple operating authorities that the Federal Motor Carrier Safety Administration actually govern. All right, as you can see, they handle things in interstate commerce. They have interstate operating authorities. The three that we normally see that we work with are the truck broker, the property broker, the freight forwarder, and the motor carrier. Those are the three that we typically are involved in. And any of those activities, they must obtain an operating authority from the FMCSA. When they apply for the operating authority, they will be getting numbers. They'll get a DOT number. The DOT number should be the same for all their operating authorities, but they'll also be getting either an MC number, an FF number, or an MX number that also is unique to that specific authority. For instance, we see MC numbers when we see motor carriers and we see truck brokers. We see an FF number when we see a freight forwarding authority, right? Now, what is the downside of not having your operating authority? Up until a few years ago, there really wasn't a downside because the FMCSA really didn't govern, or they governed, but they didn't enforce you having an authority. There was no teeth to the requirement. But there was a piece of legislation called Moving Ahead with Progress in the 21st Century that was signed, I believe, by President Obama. And it had, it was like a 600-page piece of legislation, and a little bit of that actually dealt with this type of interstate transportation. And one of the things it's changed was it said if you are caught illegally brokering or illegally operating without the proper authority, you can actually get a fine of $10,000 per violation. And that fine could go not just to the company, but to the directors and officers of a company. So the teeth that legislation put into effect created a lot of concern and attention to companies thinking, now, am I really operating this way? Do I really fit the definition of these things? Should I be getting to my operating authority? If I do, what does that mean for me? And so there was a lot of discussion, a lot of information during a period of about a year and a half that went on with our customers about that. So that piece of legislation came out, but they said there's some exceptions to this, and there's a couple of exceptions. One is if you are an NVOCC or freight forwarding, and you have a through bill of lading, meaning that, let's say the pickup was in Paris, and let's say the final delivery was in Denver, and the bill of lading says Paris to Denver. Well, the final delivery in Denver by truck is still considered to be part of that international bill of lading, and it's exempt from the broker forwarder operating authority, because the master bill or the through bill of lading actually showed the final destination. However, let's say that same bill of lading was Paris to Kansas City, Kansas. Yet the airway bill was Paris to St. Louis. So that St. Louis, Missouri to Kansas City, Kansas is now a domestic move. It is going to be governed by the FMCSA, and anyone who arranges that inland truck move must be either a motor carrier, a truck broker, a forwarder, depending upon the service. Another exemption under the FMCSA is for custom brokers that are moving things in bond. So anytime you see something that's called quote unquote bonded or in bond, it means it really hasn't entered the commerce of the United States. And by that I mean it's not there and able to be sold, right? So if it enters the commerce of the United States, it's now in the monetary commerce. It can be bought and sold. But before it enters the commerce, it's not available to be bought and sold. It's considered to be in a neutral sort of free zone. So if they are, let's say, you've got the shipment going from Paris, coming to St. Louis, and now it's going to Kansas City. Well, if it's going to Kansas City from St. Louis in a bonded carrier or in bond, then it really hasn't entered the commerce of the United States until it gets to Kansas City, because it's in bond from St. Louis to Kansas City. Now, most of the time, you don't see that. You really see the shipments clearing customs in Kansas City and then just moving on to, clearing customs into St. Louis and then moving on to Kansas City. But you do have they do have the opportunity, and there's certain reasons why they might want to delay the customs entry. So they're not doing the customs entry in St. Louis. They would be doing it in Kansas City if it's moving in bond, okay? There's also some exemptions for an international air carrier, indirect air carrier. Again, that though has to do more with a through bill of lading. Now, this is a definition taken directly from the FMCSA website. Who is a freight forwarder? The thing to remember on this one is that each of these activities is something that you need to perform. It's not you do this, or you do this, or you do this, or you do this. Each one is building. It's you do this, and you do this, and you do this, and you do this. These four things are what you are doing. When you do these things, you are automatically, by definition, a freight forwarder. Regardless of whether you applied for your freight forwarding authority, you, by definition, are a freight forwarder. And what does that mean? Well, it means you have to have the freight forwarding operating authority. And it means that you are going to have statutory cargo liability under CARMAC, which we're going to talk about. Now, there's such a thing as an asset-based or a non-asset-based forwarder. And I just actually had a conversation or email yesterday with a client about this. When you apply for your freight forwarding authority, they will require that you have the bond, which is fine, right? We write the bond, we post the bond with the FMCSA, that's fine. They will also require, however, that you have automobile liability coverage. But a lot of freight forwarders don't have trucks. That's what I mean by asset-based. They are not asset-based forwarders. They don't have trucks. They're not operating like that. So when you are applying for a freight forwarding authority, if you do not have trucks, all you need to do is request a waiver of this kind of liability, because you're not going to be able to comply with it. You don't have trucks, you don't have automobile coverage, and they will easily waive this requirement for a forwarder if you meet the requirement. Now, a motor carrier and a surface freight forwarder. So the surface freight forwarder is another definition of a domestic freight forwarder. The FMCSA calls it a surface freight forwarder. Again, kind of confusing when you have multiple names for things, but you just sort of need to get used to all the different ways people can call things. Anyway, so if you are a motor carrier or freight forwarder, you have that CARMAC liability. So here's the point you want to remember. If you remember the page where we showed the ocean carriers, the NVOCCs have $500 per unit of freight, and the international freight forwarders and air carriers have $9.07 a pound or $20 a kilo or 19 STRs. And then you saw that domestic side that said 50 cents a pound. And I said, yeah, it's not the same. It's not a statutory amount. That's when we come here, because really the motor carrier and the forwarder have statutory cargo liability under CARMAC that says you have full value legal liability. Keep in mind, I said legal liability. It's not all risk. It's not a broad responsibility. You can't be responsible for things outside your control. So for that force majeure situation, you're not going to be responsible for. If they can't prove that you caused the damage or you're responsible for the damage, you're not going to be responsible. But if you are responsible, then you are liable for the full value, the commercial invoice of that cargo. Now, how do you get out of that? Well, you can get around it, or you can limit your monetary amount by contract, like a written contract with your shipper, by a tariff that you publish. And tariffs will have different tariffs dictate what your freight rates are. Your freight rates then dictate what the liability limit you have for your cargo. So with a tariff, you can actually choose a higher freight rate to get a larger recovery, a monetary recovery from the carrier. So that's the second way. And the last way is a bill of lading, that basically stipulates what your legal liability is. So even though CARMAC says full value liability, we see a lot of carriers, a lot of forwarders that limit their monetary amount. The reason that 50 cents a pound was put in that slide was it's not uniform, it's not consistent, it's not a statutory limit, but a very common limit of liability that people use in a contract or a bill of lading is 50 cents a pound. They're saying, no, I don't want to be responsible for the full value, but CARMAC gives me an out by allowing me to put something in writing that says, here's what my real limit of liability is. So that is the option that many of our customers take advantage of. So the Carmack Amendment. So under Carmack, you have to prove that you're not negligent, right? So the burden of proof is that on you to say you're not negligent. One of these 5 reasons that you're not negligent have to apply in order to support the fact you're not negligent and you don't owe any money, right? It has to be an act of God, a public enemy or the act of war, a default or an act caused by the shipper, a public authority like a government authority, or inherent vice or the nature of the goods transported would make you not responsible. You have, in order to say I'm not responsible, it has to be one of those things. Now, when you issue a bill of lading or a contract that says what your liability is, you can typically successfully support this limit of liability, but you have to do a couple of things in order for it to be successful. You can't just tell someone, instead of that full value Carmack liability that I'm responsible for, I'm going to be responsible for 50 cents a pound, take it or leave it. You have no choice. You can't do that. It's saying you've got to give them advance notice that this is your limitation of liability, and you also have to give them an opportunity to declare a value. And typically you see in a bill of lading, you see boxes, and there should be a declared value box. You also sometimes see an insurance box, but not necessarily, not always. But you should always see the declared value box, because in order for them to limit their liability to whatever amount they want to limit it to, they have to give that shipper the opportunity to declare a value. And by the way, 50 cents a pound isn't the magic number. There is no set amount that you have to say. You could say 25 cents a pound. You can say 60 cents a pound. You can say $1 a pound. You can move that number any way you want, as long as you give the shipper the advance notice and you give them an opportunity to declare how you value. Now, what happens when they use that declared value box? What is declared value? Well, I can tell you what it's not. It's not insurance. So when we talk to our customers about cargo insurance, we offer them cargo insurance. We're giving them a first party property coverage that's going to protect their cargo, hopefully for all risks, the broadest coverage available. This is not that. This is basically saying, if the carrier or the forwarder was responsible, remember the first part of the liability is the scope of responsibility. So if the scope of responsibility says you carrier, you forwarder are responsible, then the shipper will get the monetary recovery. Because you wanted to limit your liability, let's say to 50 cents a pound, you have to give them a declared value option. Now, if they declare a value, let's say they can put any amount they want. It doesn't have to be equal to the value of the goods. There's no requirement to declare a value equal to the commercial value like there would be with insurance. You can put any amount you want. You're going to have to pay for it, and declared value is not a cheap coverage to buy. It's no less expensive than insurance. But what does it do? It basically takes that, let's say 50 cents a pound that the carrier was saying they're offering you, and it's bringing it up to whatever amount of money you put in the declared value box. So if you put in the declared value box $5,000, then it gives you $5,000 if there was at least $5,000 of damage, and if the carrier, the forwarder, was responsible. That is how you would use a declared value box. Now, why would anybody ever declare a value? I find that there's 2 reasons why. One is sometimes an insurance company, if it's a particularly sensitive cargo, they may require you to declare a certain percentage of the value of the cargo to the carrier, with the idea that they want the carrier to have more skin in the game. They want the carrier to have more interest in the cargo so that maybe they'll protect it a little bit better, because they're going to have to pay a larger claim if they don't. So that's one reason. The other reason would be if somebody has their own cargo policy, but maybe they have really high deductibles. Maybe their deductible is $25,000. So just in order to help, help them recover the cost of their deductible, they may put $25,000 into the declared value box with the hope that maybe they'll get the deductible back if their insurance policy had to pay a claim. Those are the only two reasons I can ever think of why actually anyone used the declared value box. I will say that sometimes people use it thinking it is insurance, and because there's so much confusion around domestic transportation, motor carriers and forwarders aren't the wealth of knowledge that they should be, and they sometimes lead their customers astray, telling them it's insurance when it's really not. So let's go to another definition. This is the property broker, also known as the truck broker. Who is a truck broker? Who is a property broker? Well, by definition, by the FMCSA, it really is someone that's arranging transportation across state lines for a fee, right? So they're not doing it for free. They're making a charge for it, and they're going across state lines. That's really the definition of a broker. So unlike a forwarder, unlike the motor carrier, property brokers don't have statutory cargo liability. Under CARMAC or anything else, they actually have no cargo liability. However, they have commercial liability, meaning when they arrange transportation and they choose the carrier and the cargo gets put onto the carrier's truck and they move it and then there's damage, then oftentimes people look to the broker to go, you're the one that made that choice. I'm blaming you because you made that choice. So if that is the case, unless the property broker had some type of insurance to protect them, they would have nothing in which to pay claims. And that's the reason why we have something called contingent cargo liability insurance, because that coverage will respond to claims for property brokers when the carrier's insurance fails to respond. So, as I said before, it has to fail to respond. A couple of things about contingent cargo coverage to know is that and we see there's no set amount because there's no statutory cargo liability. There's no set cargo liability limit, contingent cargo liability limit. But there's a customary one. We see a lot of $100,000. And we see a lot of motor carriers having primary cargo insurance of $100,000. It's a very common limit. So what if a broker says, I want to buy $250,000 of contingent cargo coverage? Would we sell them that? Yeah, we would, but we would tell them, remember, this is not excess coverage. Your policy is only going to respond if the primary trucker's policy fails to respond. So if you hire truckers with $100,000 of motor truck cargo coverage and you buy a $250,000 limit of contingent cargo, your policy is only going to pay $100,000 because you hired the truckers at $100,000. It's not excess of the trucker. So don't bother buying a limit higher than the trucker's limit that you hire. So that's really important because there's a lot of confusion about that. Oftentimes, contingent cargo policies will have a warranty or a condition of coverage that basically says you have to have proof of coverage, proof that the carrier that you hired had motor truck cargo insurance. In order for us to pay a claim, you've got to show that you knew that they had it and that they had it. This is hard to do if you're co-brokering. And we see what we call co-brokering or double brokering. We see triple brokering. What does that mean? So if someone's hiring a broker and the broker contracts with the carrier, that's just brokering. But if the customer comes to a broker, the broker contracts with another broker, and that broker hires the carrier. Now we're in a co-brokering or double brokering situation. And by the way, it can get worse, where a broker hires a broker who hires a broker, and that's triple brokering. The coverage, if your coverage stipulates that you must have a certificate of insurance for the trucker that you hire showing they have cargo insurance, that's going to be very difficult to do if you're co-brokering or, God forbid, triple brokering, because you're not in charge of hiring the carrier and you're not the one getting the certificate of insurance. So there's ways that we can amend our coverage to fit some of the co-brokering situations, and we can, you can get into that as you get more involved with insurance. The other thing to know about contingent cargo insurance, it is a specialty policy. They don't read the same. They are very different. And I can't stress to you how different some of these policies are. I remember seeing one, they weren't a customer at the time, but I went to see them and they showed me their contingent cargo policy. And I'm looking at it and I'm like, you're never going to be able to collect any claim on this. You have just spent $4,000 for something you're never going to be able to use, because the requirements that they have for you under this policy required that you knew not only if the carrier was insuring the cargo, had the motor truck cargo coverage, but what the coverage they had was. What was the carrier's warranties? What was the carrier's exclusions? Did they have commodity exclusions? Was there a theft condition? All of these requirements that this policy put on the broker to know about the carrier were impossible for them to know. And so that's why you cannot make any assumption with these specialty policies that they are alike in any way. You really have to look at the policy form to make any kind of judgment on the coverage. All right, so because we advocate and encourage our customers to have E&O coverage, and there are some claims that might be seen as an E&O, except when you are a custodian of cargo. So let me give you a couple of questions. Does E&O coverage protect our customers for physical loss or damage of cargo? No. So first of all, understand that E&O, or also called errors and omissions insurance or professional liability insurance, is protecting the customer for allegations of wrongdoing, of mistakes, of errors and omissions, unintentional errors and omissions. So we often have seen claim types that say, we blame you because you chose the carrier, and so the carrier that you chose was negligent, or they were a bad choice, or you didn't vet them well, or whatever allegation you want to make. But you're being blamed, your customer's being blamed because they made a bad choice. That could often be an E&O situation. And we see a lot of E&O claims for what we call negligent selection. But it is not true if you're the custodian of the cargo, meaning not necessarily that you had possession of the cargo, but that you had, that it was in your care, custody, and control. It was moving most likely under your bill of lading. It may not be in your truck, it might not have been in your warehouse, but it just might be moving under a bill of lading with your name on it. Or it might be in a warehouse, under a warehouse agreement with your name on it. When you are custodian of cargo, the coverage that needs to respond to physical loss or damage of cargo is cargo liability, some form of cargo liability coverage. E&O is not there to replace cargo liability. That's not what it's doing. So therefore, yes, E&O could pay for a negligent selection allegation, but not if you're the custodian of cargo. So this is a little bit more of the same. No, it didn't before, but if you are a custodian, but if you're not a custodian, so you can be a custom broker or freight forwarder who doesn't issue a house bill of lading. It's also possible as a property broker, and even though you have contingent cargo, you're not a custodian of the cargo. So potentially you can have coverage apply to a property broker as well for a negligent selection claim. Now, it's very important with our customers who contract with motor carriers that they do some type of screening of the motor carriers. As you've heard with property brokers, they need to have a certificate of insurance from the carrier to make sure the carrier had the right cargo coverage. So that's something they want to do in screening, but there's more to the screening because there's more liability involved with some of the services that our customers are performing. So everyone that is contracting with carriers needs to have some type of vetting process. The vetting process can include you're checking to see that a carrier has or a forwarder, someone has a valid operating authority. You can check that through public information on the FMCSA website. All right, it's important to have a TIA or transportation intermediary and the carrier agreement. So for instance, if you've got a customer who is a broker, who's a truck broker, then that broker should have a carrier agreement. It's called a broker carrier agreement. There's also forwarder carrier agreements. There could be broker to broker agreements when you have co-brokering situations. You have shipper to broker agreements, shipper to carrier agreements, shipper to forwarder agreements. So there's all kinds of agreements between the two parties that are contracting with each other. It's important to have these agreements because you want to transfer the risk of liability to the appropriate party, meaning the people that actually do the damage. If you are a broker, you're not using your trucks to carry a cargo. You're relying on a carrier. So it only makes sense that you have certain standards for the carrier, and then that agreement spells out what they're responsible for. If you don't, then the broker could be seen as the one responsible when the broker had no control over that cargo. It was the carrier that had it. So the contracts help define responsibility, spell out the services each are performing, define payment terms, liability terms, their relationship, the nature of their relationship, all of those things. That's really important. Nowadays, we see more and more where it is difficult to get certain types of insurance without having these agreements in place. Another vetting process is making sure that they have a good safety record. This, again, is available under the FMCSA website. These are that's public information. And then lastly, having the insurance certificate. The insurance certificate basically outlines the insurance limits that the carrier, the forwarder, whoever you're asking for it has, and gives the terms of the policy and things like that. So that's one of the ways you vet a carrier. So with the carrier agreements, you can see that the transfer of risk is the main goal, and that there should have certain things in the agreement that basically says these are the standards that we have for the carrier, their insurance company being A- rated or better, using carriers with satisfactory safety ratings, making sure they have the right kind of coverage. Now, one thing that's really easy to be confused by is the certificate of insurance. So the certificate of insurance I'm talking about is what we call the Accord certificates, which is the standard insurance certificates that insurance agents and brokers issue every day, all day long. And the important thing to remember about a certificate of insurance, it's not a governing document. So one of the things that people get very confused with is and this is really true with domestic transit, You get a certificate of insurance from the carrier. It shows they have $100,000, or let's say they have $250,000 of motor truck cargo coverage. And you as the shipper, or even as the broker, are going, oh, great, well, this shipment's only $100,000 and they've got $250,000, so I'm good. The problem is, all it's telling you is this is how much coverage they have. It doesn't transfer any coverage to you. It's no guarantee of coverage. It's not a governing document. So although you need to have that document in order to make sure that you've maintain the requirements of your insurance coverage, making also sure that they have coverage, it's not giving you anything in a claim. You have to go back to what the governing document of the transportation was, which might have been the tariff, could have been the bill of lading, could have been a contract. So the certificate of insurance a lot of times is just information. It's never a governing contract. When I've said before about how we see multiple names used for the same thing, this is very true when it comes to cargo insurance. You'll see on the certificate of insurance the terms cargo insurance, cargo liability insurance, motor truck cargo insurance, motor truck cargo liability insurance, motor cargo legal liability insurance. Anyway, the point is, you'll see a lot of different descriptions of coverage. Nothing tells you anything. These are specialty policies. They're not the same. You will have no idea what the coverage is. You won't know if it's all risk coverage or limited legal liability coverage. You won't know anything. It's not for you to know. There's no way you can operate in a world where you would have all that information. It would be wonderful, but there's no way you can do it. So don't get caught up in that, but just know this is the type of coverage you're looking for. We also ask our customers, and this becomes a requirement under certain types of insurance, is that when they get a certificate of insurance from the carrier, that they ask to be added as an additional insured on auto liability, general liability, employer's liability, and umbrella liability if available. Now, what does that mean? Additional insured status requires or enables whoever's added as an additional insured to be able to share their liability insurance with them. So if XYZ Trucking Company is hauling ABC Brokers freight and XYZ gets into an accident and they hurt someone, and then XYZ gets sued and ABC Truck Brokerage gets sued, then ABC gets defense under XYZ's policy because they have been named as an additional insured. XYZ has to share their insurance coverage, their insurance limit with them. When there's something that happens, they do what XYZ does that brings ABC into a claim. That's what it does. So it's something that's significant. It's not done lightly because you're sharing your limits with someone. We have had many occasions where truckers will say it's going to cost me X number of dollars to add you as an additional insured, or my insurance company won't let me do this or something like that. So there's always a lot of pushback, but this is a requirement for certain types of insurance coverages. And it's something that if you make an exception, you want to make an exception very, very rarely. So you also want to make sure, if possible, that the coverage that they give you is primary and non-contributory, and that there's also a waiver of subrogation in respects to liability policies. These are terms that are put in the body, in the remarks section of a certificate. So you have the certificate that will show all the different coverages and limits and policy numbers, policy terms, and then you've got the remarks section where you can put in some of these other things. And what it does, I'll tell you a quick story. On the waiver of subrogation, we had a customer a few years ago. They had a warehouse. It was a freight forwarder. The trucker pulled up to the dock. The trucker got out, unloaded. It was a machine, and dropped the machine. And it was, I don't think, $400,000. And their insurance paid it. And they then went after our customer, who was the forwarder, who had the warehouse. And the allegation that the trucker made against the forwarder was, you didn't have enough signs up in the warehouse that really promoted safety instructions. You need to give us safety instructions. You know, you really needed more signage. We just, this wasn't a safe environment to work in. We blame you. Now, this was regardless of the fact that that trucker had been to that warehouse many times and delivered many things. But at the end of the day, our customer's general liability policy actually paid $35,000 to them. And I went and asked the underwriter later, and I said, well, that's, so bizarre. They just ended up writing a check because they didn't want to be litigated. I said, but if they would have had a waiver of subrogation on that certificate, because they had a certificate, but they didn't have waiver of subrogation. If they would have had the waiver of subrogation, would you have paid that claim? He said, probably not. So that was a good lesson. When I mentioned the FMCSA website, what is actually the site that you can find a lot of this information is on the safe, what I call the Safe Persist. I go on Google and I SAFERSYS, and you put that in, it will come up. And then you open it up and you look at the licensing and information. The licensing information, you can search by name. You also have to put the state that they're in, and then you can find out, you can look at their operating authorities, check the safety records. You can check to see if they have auto insurance on file. You can see what bonds they might have on file. Now, there used to be a place for cargo insurance, because there used to be cargo insurance filings that were required, but a number of years ago, they decided no longer to monitor that. So they don't monitor cargo insurance, even though there is requirements for a freight forwarder and a carrier to have cargo insurance. They don't require the filings anymore, except if you are a household good personal effects forwarder or carrier. In those cases, you do have to have a filing, but that is usually not the customers that we have. So now, some of the other exposures, as I said before, where you've got, a bodily injury situation where someone's driving because you've hired them, put them on the road, and somebody gets hurt. Now we see lawsuits, we've seen judgments, litigation, where customers that are considered transportation intermediaries, really, the people that are not actually carrying the cargo, but they're the ones that are contracting it, they have had judgments against them in multiple cases, very large amounts, under what they call vicarious liability. So the vicarious liability, the idea of vicarious liability, is that you're somehow in control or responsible for someone else's actions. It would be like Roanoke being responsible for you as their employees' actions. They hired you, they screened you, they manage you, they train you. If you do something wrong, yes, it might be your fault, but ultimately they're responsible. That's the idea of vicarious liability. One thing that you don't want, or your customers don't want to be seen as, is they don't want to ever be seen as the agent of the carrier. They never want to be seen as someone that's in control of the carrier, because the more they're seen as they are the agents of the carrier, or they're in control of the carrier, when there's a claim, they could be seen as having vicarious liability. They somehow could have controlled the situation. That's one of the judgments that happen in bodily injury claims is this vicarious liability. The other thing is the negligent hiring. If the transportation intermediary failed to use reasonable care, and going back to the things that we talked about, the safety records, having a contract which spells out what the requirements of the carriers are, what the standard of performance is. All of these things make a difference, because if you are alleged to be negligent in your hiring, then our customers need to have something to defend themselves. That's the reason the vetting process is so important, because if they are sued, you can only buy so much insurance. I mean, if somebody dies or is severely handicapped from an accident, and you get brought into a lawsuit, well, what's the value of a human life? What's the value of someone's life living as a quadriplegic? Millions and millions. You see a lot of zeros. So how much insurance can you really afford to have? So insurance is not your only option to protect yourself. Just as important is, how do you do business? How do you screen your customers? Screen your carriers? What process do you have? Do you follow that? All of those are just as important as having insurance. I've already talked about this, about vicarious liability and some of the things that will appear to be as if you were controlling the carrier. One of the things that is kind of a double-edged sword is when you give instructions. You would think, if I gave very specific instructions to a carrier, then the more instructions I give, the more specific I am, the better we're going to be, because if they make a mistake, and if they don't do what I say, and they don't get this, to the destination by this time, then they're on the hook and they're responsible. And that's a common sense observation. But if you think about it this way, if I tell my motor carrier, you have to get my shipment to Albuquerque, New Mexico by Friday at 12. That is your deadline. You've got to get there by Friday at 12. Well, what might they have to do? That might not be make safe decisions to get there by Friday at 12. If they get into an accident, if they harm someone, and that information comes to light of all the stuff that you told the carrier they had to do, now it's going to seem like you had some control over the carrier. They were following your instructions. They were meeting your deadlines. And that's why it's a double-edged sword. On one hand, you have to give specific instructions. On the other hand, if you are giving too strict instructions, it could be seen as you've got control over them. And that's the thing. You never want to be able to, anybody to ever prove that you had control over the carrier. Now, our customers who are transportation intermediaries, what kind of insurance would they need in order to protect themselves from bodily injury claims? Well, the carriers and the forwarders that have trucks, they have primary auto or truckers liability coverage. But if you don't have trucks, but you still have the exposure because you're contracting carriers, then the coverage that you would need is something called contingent auto liability insurance. So if you remember us talking about, for property brokers, contingent cargo liability coverage, it's kind of the same idea, meaning that you're not primarily responsible. You're really not doing the work. You're hiring it done. But you recognize that if they do it wrong, if they damage cargo, if they hurt someone, that you can be brought into a claim just by the fact that you hired them. It's not excess coverage. The coverage is basically protecting you if you get pulled into a claim because someone else is driving on your behalf and you're brought in and seen to be responsible. The coverage is for you, the forwarder, you, the broker, you, the customer, whatever operation you are whatever hat you're wearing operationally, that coverage is going to protect you. It's not designed to protect the trucker, but it's designed to protect you. Now, if you're an additional insured under the trucker's policy, you might say, well, you know, what happens? I mean, I have coverage under the trucker, but depending on how many people who might be added as an additional insured, and if they have $1 million, that coverage doesn't go very far, that money doesn't go very far. And so this is just a protection to make sure that, and we have seen this, by the way, I've seen this in the cargo world, the cargo side, where, you know, a broker has had the trucker's insurance certificate, and then when it came to a claim, they found out the trucker hadn't paid the premium, and so their coverage had expired, but our broker never knew it, and then their contingent cargo policy had to pay because the trucker didn't have coverage. So even though you see a certificate, or even though you might be named as additional insured on a liability insurance, you can't put all your eggs in that basket. All right, so this is our last slide, which really talks about, we have a lot of great resources. These are things you should be looking at. These are documents that we give customers and prospects. They have a lot of good information. We have more than this, but these are just some examples of ones that we do have that can be helpful to our customers to educate them on things that are really important. So thank you. I'm open to questions. Any questions? I hear nothing.